Hello everyone and welcome to today's Mondac webinar in association with Shy Wei Partners, who will be providing a practical guide to Chinese employment law with particular focus on hiring modes and termination of employment under PRC laws. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Shang Liu is deeply experienced across all employment related practice areas. She regularly advises clients on employment relationship, management of foreign employees, protection of female employees, protection of trade secrets, non-compete, union issues, collective agreements, remuneration, social insurance, benefits and leave for employees, reorganization of employment structure, protection of employees' personal information, occupational health and production safety. Hong Wan Zhang can advise clients in both employment-related, non-contentious and contentious matters. He regularly advises clients on employment relationship, non-compete and protection of trade secrets. Dr. Zhang also regularly assists clients with due diligence investigations and compliance management related to employment, the transfer and termination of employment often seen in important M&A projects, as well as clients' economic layoff requirements. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session at the end of today's presentations. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan, and hello everyone. I'm Chang, and it's a pleasure to meet all of you for this seminar. So when it comes to PRC employment law, there's a lot of information we'd like to explore with you. And today we've chosen to focus on two pivotal aspects of employment management, so hiring and termination. And these are the cornerstone of employment relationships in China because they represent the beginning and the end. So let's begin with hiring approaches. Next, please. Yeah. So let's begin with the hiring approach. The first approach is full-time employment. This is the most commonly adopted hiring approach. And full-time employees are generally expected to provide exclusive services to their employer. And there are three types of employment contracts for full-time employment, and as is illustrated on this page. So first one is fixed term. For new hires, many employers prefer to have them signed a fixed-term employment contract, because this allows them to have the flexibility to let the contract expire if the employee is found unsatisfactory. And the second one is open-ended employment contract. There's a special rule under the law we think you should be aware of. After two fixed-term contracts, the employer has to offer an open-ended contract unless the employee says otherwise. However, you know, China is a big country and different cities have different local practice. So take Shanghai, for example. Shanghai has its own local practice on this because it gives employers a choice that upon the second contract expires, the employer can renew it or to terminate it. The rule of an open-ended contract, as we just mentioned, is only enforced when the employer decides to renew. So this perspective is unique and widely accepted in Shanghai, and it makes the city a bit more employer-friendly compared to Beijing and other Chinese cities. The third type of full-time employment contract is named as employment contract that expires upon completion of certain assignments, or we call it project-based employment contract sometimes. This approach connects an employee's term of employment with a specific project rather than specifying a fixed duration for the contract. So typically, a project-based contract sets goals or criteria for project completion. As you can imagine, this helps avoid disputes when the contract reaches its expiration date. Then we move on to the necessity of employment contract on the next page. Now let's see why having a written employment contract in China is a big deal. Under the law, it's not just a nice to have, it's a must for the reason of protecting employees. So employment contract is a mandatory document and it is different from offer letter. It is an agreement with the contents required by the law, and it is usually executed when an employee joins the company. And if it is not signed when the employee is on board, then the contract must be executed within 1 month from the commencement of employment. And if an employer fails to establish a written employment contract with an employee within the initial months, then commencing from the second month up to 1 year of employment, the employer will be obligated to pay the employee double the monthly salary. And this means, in addition to their regular payroll, the employer is obliged to compensate the employee with an amount equal to their regular payroll, which is the double salary difference. And the employee obviously can receive the double salary difference for up to 11 months. And see the last section on this page. If after 1 year from commencement of employment, an employer has not concluded a written employment contract with the employee, then it will be considered an open-ended contract between the parties, and this will be very problematic for the employer. Then let's move on to the part-time employment. On this page, you will quickly see some clear differences that set part-time employment apart from full-time employment. So the pros, the first one is flexible in contract form. So it is not mandatory to have the part-time employee to sign a written employment contract, but it is advisable to have one because you will have clarity and it will give you protection on the interests and rights. And second, termination flexibility. So employers can terminate part-time employees without specific grounds, unlike full-time employees who require statutory basis for termination. And Hongyuan will demonstrate more about termination later. And the third one is economical. So it's more cost-effective compared to full-time employment because part-time employees do not require severance pay, which is different from the requirements for full-time employees. And there are also cons. So first, no probationary period is allowed. Given the flexibility of this hiring approach, there's actually no need to establish a probationary period, since termination of part-time employees is very flexible, as we just mentioned on the pros section. And working time restriction. So part-time employees must not work more than 4 hours per day and 24 hours per week. If an employer regularly exceeds these limits, then the employees might be considered as full-time employees. And in that scenario, all the employer obligations for full-time employees will be on the employer, as you can imagine. And the last one is salary payment frequency. For part-time employees, the salary cycle should not exceed 15 days, which is different from full-time employees who usually receive monthly payments. So to sum up, part-time employment is often ideal for hiring temporary personnel such as cleaners and other short-term roles with limited working hours. Next page, please. Yes, on this page, you can also see that we have alternative hiring options. So first, under the outsourcing approach, companies engage a service provider rather than hiring employees directly. For instance, a company contracts an IT maintenance service provider who sends their employees for on-site support. And in this model, the service provider is the employer and is responsible for the assignments, salary, social insurance, and other employer obligations. The company, on the other hand, only pays service fees without bearing employer responsibilities. The service fees under this approach may be higher than maintaining in-house employees, but this approach is adopted when a company needs specialized services for a specific period of time, but wishes to avoid direct hiring. The concerns may be like headcount limitations or long-term planning. Some other companies also take labor dispatch as an alternative. So labor dispatch is similar to outsourcing in that the companies do not hire employees directly, but engage a vendor to provide services. However, there are some differences between these two approaches. The advantage of labor dispatch is that companies receiving the employees can manage them as they see fit, while for outsourcing, you cannot directly manage the outsourcing employees. But the downside is that the receiving companies bear obligations that are similar to those for employers required by law. So this approach, generally speaking, is used only in limited scenarios nowadays, but it's frequently used in the past. For example, for foreign companies that only have representative offices in China, they are not qualified employers under the law, and they can only hire employees through different alternative options such as labor dispatch and outsourcing. So sometimes labor dispatch might be their primary hiring route. So this basically concludes our sharing on hiring approaches in China. You can choose appropriate hiring approaches based on the needs. So now I will hand the microphone to Hongyuan, and he will give you more information about employment termination in China.
Thank you. So my part will be termination of employment. Hopefully not too boring for you guys. You probably already know China's employment laws are extremely employee friendly, and multinationals that have operated in China for many years still find PRC employment laws difficult to understand and to deal with. So you are not alone if you are having some issues, and we are here to help you, to give you a big picture of where PRC employment law is in the whole world. If you can see a brief comparison between different countries. So for mainland China, Germany, Taiwan, Japan, Korea, their employment laws are employee friendly. You know, China kind of mainland China kind of copied some concept from the German and Japanese employment laws. So they are more or less similar to each other. And employer-friendly examples are Hong Kong, Australia, Singapore. You know, in those countries, it's usually easier to terminate employees compared with a situation in China. So a typical example of difficult termination in China is that termination needs to be based on statutory grounds. For example, gross misconduct, incompetence, which we will cover later on today, and you know, termination at will, employment at will, like what you have in the US, you know, Hong Kong, that really doesn't exist in China. So whenever you want to terminate an employee, you should have a statutory ground and the supporting evidence. Otherwise, the termination will be unlawful. Another example of the employee-friendly employment law for China is that dispute resolution is basically free of charge for employees. So arbitration proceedings are free, and the litigation proceedings, they only cost 5 or 10 CNY, which is barely anything really. So this kind of system, the aim is to encourage employees to sue employers for violation of their rights. And when you have an arbitration or litigation case, the burden of proof is reversed for employers. So what it means is that after an employer terminates an employee, the employer needs to prove that the termination is lawful, or otherwise the termination will automatically be considered unlawful. So reverse the burden of proof. Next slide, please. So before we get into all the requirements of different termination grounds and the PRC laws, we can have a look at all the consequences for unfair dismissal. So after an employee is terminated, that employee can initiate employment arbitration and litigation. So eventually, there will be a judgment saying that the termination is lawful or unlawful. If the termination is considered unlawful, employees, they can request either reinstatement with the back pay or double severance payment. All right. So for employees who would like to request reinstatement with the back pay, employers can try to prove that the employment contract can no longer be performed. In that situation, only double severance payment will be supported. And if not, the employment contract is considered being able to be performed, then reinstatement with the back pay will be supported. So I will just give you an example. In some situations, in most situations, reinstatement with the back pay is actually the worst scenario for employers. So if an employee's salary is let's say 50K CNY each month, and in Beijing, the arbitration and the litigation time can go up to at the moment around 2 years. That's 24 months. So 24 months multiplied by 50K. So when that employee wins the case and the termination decision is considered unlawful, so the employer would have to reinstate that employee and at the same time pay that employee 1.2 million as the salary loss for the arbitration and the litigation. So that's one example, of how tough PRC employment laws can be. Next slide, please. So there are many types of termination under PRC laws. Mutual termination is the most frequently used termination mode in practice. However, today we focus on unilateral termination, and within unilateral termination, there are immediate termination by an employer and termination with prior notice by employer. Today we'll focus on these two, which are the most frequently used unilateral termination grounds under PRC employment laws. Next slide, please. So within immediate termination by employer, the most frequently used termination ground is actually a gross misconduct. So what it means is that an employee has committed gross misconduct in violation of the employer's internal policies. And in that situation, the employer can consider unilateral termination. Now we can look at some of the requirements for termination based on gross misconduct. Next slide, please. So the first requirement is that an employer needs to have well-defined regulations about the misconduct. So an employer needs to list what kind of actions will be considered gross misconduct in the employee handbook or other internal policies. And the disciplinary actions will also need to be outlined in the employee handbook. So what you need to do is that you need to have a section in your employee handbook, and in that section will be mainly about gross misconduct, right? In that section, you will need to describe as many examples as you can do of gross misconduct account, and you will need to link the different gross misconduct accounts to the consequences of unilateral termination. So you need to make it very clear, if employees they do this, then that will result in unilateral termination of employment. Otherwise, if anything is unclear, when you terminate an employee, it gives that employee a chance to argue for unlawful termination. And the second requirement is that in addition to the internal policies, an employer needs to have adequate evidence about the employee's misconduct. So, for example, if an employer claims that an employee has been taking kickbacks, from the suppliers, and that is a violation of the employee handbook, the employer needs to have evidence about that employee's action. For example, bank transfer records, for the kickbacks. That kind of evidence you need to have. And as you can see, usually in practice, it's very difficult to find sufficient evidence because, when you investigate employees, they wouldn't be willing to reveal any evidence to you. So you would have to kind of ask around, you ask the suppliers, which might be kind of strange. And you can ask other employees, they might be refusing to tell you what has been going on either. So it's difficult in practice, and usually employers, they need to think out of the box as to how evidence can be obtained for employees' gross misconduct. And by now you might be wondering, well, how can we make sure that internal policies are effective and they can be used against employees in legal proceedings? This question has been answered under PLC laws. So there is a procedure called consultation and publicizing procedure, which every employer needs to do in order for them to use their internal policies against the employees when it comes to termination based on gross misconduct. So consultation procedure means that an internal policy needs to be discussed with the employees' representatives Congress or all the employees for the first round, and then the second round of discussions need to be done with the trade union or the employees' representatives, and that's the consultation procedure. All right. Some of you might be wondering, well, we don't have an employees representatives congress. How can we complete the first round? So the general way to get around it is you can send an email to all the employees with the internal policy as an attachment, asking for their feedback on this policy. So you can say to them, look, this is the new policy. Please respond to this email address, with your feedback by a certain date. That can be in practice in general considered that an employer has completed the first round for consultation procedure. And for the second round of consultation procedure, which is the discussion with trade union and the employee or employees representatives, some of you might be wondering, well, we don't have a trade union, how can we do it? In practice, in most situations, if an employer doesn't really have a lot of employees, maybe you have 20 or 30 employees in China, you can just organize a meeting with all of them, or by or in different groups, with the employees, and that is considered adequate for meeting the requirements of the second round consultation procedure. So there are also many other ways we can consider using, in practice, just to list a few for your consideration. And publicizing procedure, it basically means that an employer needs to have employees sign off a policy which has just been discussed with all the employees, and that is considered sufficient evidence for publicizing procedure. So next slide, please. Now we can look at a case about termination based on gross misconduct, and you can have a taste of how difficult it is in China to terminate employees. So let's look at the facts first. Mr. Zheng is an employee of JP Morgan, company we'll know of, and the employee handbook basically says that falsification of reports, records, or documents is a serious violation of the internal policies and will result in dismissal, right? And what this employee did was that in 2011, this employee applied for reimbursement of car rental fee of around CNY 2,000, and then in 2012, this employee applied for reimbursement of two business entertainment expenses of CNY 5,000 and CNY 4,000, so about 9,000 in total. And when applying for the reimbursement, this employee said the other employee, Chen, was in Chengdu and with this employee and witnessed how the two expenses occurred. So this employee was saying that, look, I've got a witness of all the expenses. That employee Chen was with me when I was spending the money, and but what actually happened was that Chen was at Beijing at the time, so Chen wasn't really with this employee in Chengdu. This was found out by JP Morgan later on, and in 2013 January, JP Morgan basically dismissed this employee based on gross misconduct. Well, you might be thinking, well, what this employee has done is intolerable. The unilateral termination should be considered lawful, right? But that's not the situation in China. Next slide, please. So what the court said is that, in order to use your internal policies against employees in legal proceedings, employers need to have their internal policies go through consultation procedure. And without consultation procedure, the evidence can't be admitted, and the unilateral termination based on that piece of employee handbook will be considered unlawful. So eventually, the court held that the termination of JP Morgan was illegal because its internal policies didn't really complete the consultation procedure. So from this case, you can clearly see it's not even the question of right or wrong in practice. It's mainly about whether you have met the statutory requirements for unilateral termination. If you haven't, regardless of how severe an employee's gross misconduct is, it is very likely that your termination decision can be considered unlawful. And now let's move on to the next slide. So termination with prior notice by an employer, there are three termination grounds under this round, and the most frequently used termination ground in practice is unilateral termination based on incompetence of an employee. So let's have a look at all the requirements. Next slide, please. So termination based on incompetence is lengthier. It's more complicated compared with termination based on gross misconduct. In order to prepare for unilateral termination, an employer needs to go through these 5 stages of termination preparation. So the first one is an employer needs to have a performance assessment policy and agreed KPI. That's very easy to understand. You need to have a policy through which you can review an employee's performance, and you need to have some KPI in order to hold employees responsible for failing to meet the targets. And the second stage is that an employer needs to evaluate the performance of an employee based on the policy and the agreed KPI. So you need to follow the procedures in your policy and the KPI agreed with an employee when you are evaluating the performance. So yeah, it sounds easy, but in practice, most of the time it's not easy, because employers, when they are trying to evaluate an employee's performance, some of them, they don't really follow procedures in their policies or the agreed KPI. They change the procedures randomly according to what the management has decided, and that is a big risk factor for employers in practice. And the third stage is that after an employer evaluates an employee's performance and decides that this employee is incompetent, that employee needs to be provided with training or transferring to another position. So you only need to do one of them. You don't need to do both training and transferring. And training and transferring, they can usually last from 1 to 3 months. The longer you give an employee to improve, the more reasonable your decision is going to appear in front of judges and arbitrators, and the more likely you will be supported for lawful termination. However, the longer you give an employee, the longer this whole process takes, and the more expenses will be incurred. So after training or transferring to another position, an employer needs to evaluate the performance of an employee again. So stage 4 needs to be done again according to the requirements in stage 2. And then after you evaluate the performance of an employee again, you can proceed to unilateral termination. All right. And just to give you how difficult it is, just to give you a big picture of how difficult it is for employers to unilaterally dismiss employees in China based on poor performance. We've done a case research like a couple of years back. We haven't done one recently, but I don't think the result has changed much. So in that case research, we got like 100 cases of termination involving poor performance of employees, and in fewer than 2 cases, we found that the employer's termination decision was considered lawful. So most of the time, an employer's decision of termination based on incompetence will be considered unlawful in practice. So termination based on incompetence, statistically speaking, is more difficult than termination based on gross misconduct. We can have a look at a case, and then you can have a better understanding of the different requirements in practice. Next slide, please. So this employee is a sales employee of Hewlett Packard, and this employee signed a sales letter with the line manager, and in this letter, this employee's sales goals were agreed. And in 2012, this employee only completed 57% of the sales goals, and Hewlett Packard issued a warning letter to this employee, informing this employee that the performance was really poor, and the company hoped to help this employee to improve their performance through training or transferring to another position. So what Hewlett Packard did was that it provided two trainings to help this employee to improve, and those trainings, they were mainly on calculation of bonus. And after that, Hewlett Packard evaluated the performance again and informed this employee of the result of incompetence. And then, termination was done based on incompetence. Let's have a look at what the court said about this case. Next slide, please. So the court said that, although this employee only completed 57% of the goals agreed, however, Hewlett Packard didn't really specify the standard for failing to meet the sales goals. So what it means is that Hewlett Packard didn't really say when you are under 60%, you are considered a failure. So that wasn't really said clearly to this employee. So what the court meant is that, well, this employee completed 57%, but who is to say 57 is a failure? Maybe 50 above 50 is considered a success. So based on this reason alone, the court held that the termination was illegal and supported reinstatement. I think that's all of our slides today. Right, next slide, please.
Thank you very much, Hongwan. Thank you, Chang, for that incredibly detailed, informative presentation from both of you. We really appreciate your time today. And we are now going to move on to our Q&A section. We've had some great questions in from our audience. Chang, I'm going to hand the first question to you from Kaylee, who asks, I'd like to know more about offer letter. 1, is it a common practice to have it? 2, how much later should the employment contract be signed? 3, can employer or employee change their mind after an offer letter is signed? And 4, is there still employment if the new hire refuses to sign the employment contract having an offer letter is signed?
Okay. So the offer letter issue is related to hiring, as we just shared. The first question is that is it common practice to have the offer letter? So yes, it is common practice in China to have the offer letter because it confirms the upcoming employment establishment between the employer and the employee. And second, how much later should the employment contract be signed? As we just shared, within 1 month after the employee starts working for the employer, the written employment contract must be signed between the parties. Otherwise, the employer will bear the double salary difference. And that would be problematic. And the third question is that can the employer and the employee change their mind after an offer letter is signed? Normally, yes. However, since the offer letter is a form of contract, although it is not an employment contract, and if one party breached the contract, it may be required to bear the loss of the other party. And the request for loss from the employee may be rarely seen in practice for difficulties in proving the loss. But the request for loss from the employer may be successful. Sometimes the employees often establish the loss suffered by themselves by proving the salary he received from the previous employer and that he quit the job in order to join the new employer. So the refusal to have them on board may result in the loss of their income. And we have seen in practice that employers are required to pay several months of salary based on the previous standard from their previous employer. And sometimes the court or the arbitration commission will support some of the requests from the employees. And the last question is that if there's still employment, if the new hire refuses to sign the employment contract, if the offer letter is signed, no, unless the new hire commences work for the employer. So as long as they hasn't started working, then the employment is not established.
Brilliant. Thank you very much for that answer, Chang. Just to our audience, you can see in front of you the WeChat QR codes. If you would like to submit a question that way, please absolutely do, but you can also submit a question through the toolbar. We have a question from our LinkedIn channel where we are streaming this webinar as well, and a question from Enrique. Chang, I'll hand it to you, but Hongwan, please do jump in if you would like to answer as well. Is it allowed to agree on an exclusivity clause with part-time employees?
Generally speaking, yes, because the employer can ask the employees to abide by their policies, and exclusivity can be one of the policies. And there are no restrictions to forbid the employers to set such requirements on the part-time employees. However, we should say it is uncommonly seen in practice because the working hours of part-time employees are very limited, and employees' expectation is normally that they may simultaneously work for more than one employer. Nonetheless, if the employee can be persuaded to accept the requirement, then the arrangement should be fine. Yes, and also note that in this scenario of failure to follow this policy, which means if the employee fails to follow this requirement, the employer may not be allowed to request liquidated damages from the employees, even if it is agreed in writing, because liquidated damages requested from employees are very limited. It's limited to certain scenarios under the law. However, if the loss for the employee's breach can be proved, then the employer's request might be supported. But you can imagine that it will be difficult since the laws and the relationship between the laws and the employee's violation of the policies may be very hard to establish.
Brilliant. Thank you very much for that, Chung. We've had two questions in. Well, one is a clarification, one a question from Elsie. And I believe this is in relation to your presentation, Hongwan. The clarification, for termination, did you say that the severance pay is up to 24 months times the monthly salary?
Not really. So that depends on the ground of termination. So for the two termination grounds we covered today, one is unilateral termination based on gross misconduct. If an employer uses that ground, then no severance is required. So an employee can be terminated with immediate effect without any severance being paid. And if eventually, the termination decision is considered lawful by arbitrators and judges, no severance needs to be paid. However, if the termination is considered unlawful, then that employer can pick either reinstatement with a back pay or double severance payment. And so that's the way of understanding this whole structure. For termination based on poor performance, when doing termination, an employer needs to pay statutory severance plus 1 month salary as the payment in lieu of notice. Also, you can notify the employees 30 days in advance as well to replace the payment in lieu of notice. And how to calculate statutory severance? It's a bit complicated in China because each region has a different practice. However, the general rule is that for each year of service, an employer needs to pay 1 month of salary to that employee. And the monthly salary, when you are calculating the monthly salary, you need to take into all the income, including salary, bonuses, allowances, all the cash income paid in the 12th month prior to termination. Yeah, that's the general rule. Yeah, I think that also answered Elsie's second question. For monthly salary, does it include all types of allowances? Yes, it does.
Brilliant, thank you. We've had two further comments from Enrique. I'm sure Chang, Hongwan, you can see those. in the chat. If I read those out for the audience and then you can respond. Enrique says, in that case, the company could have filed a criminal complaint against Zeng for the false reimbursement actions and then terminate on those grounds, criminal conduct. If the incompetence occurs during the probationary period, does training or transfer of the employee still a requirement for lawful unilateral termination?
Yeah. Well, the company can try to file a criminal complaint against this employee, but what happens in practice is that you know, this amount is not a hefty amount. It doesn't really trigger you know, a criminal offense. So what the you know, what the police will do is that when they hear this case, they might just ignore your request because you know, of what I just said. So what I think the employer in that case can do is try to recover the loss through a civil lawsuit or an employment lawsuit. Yeah, I think that is doable. But you know, we don't have all the evidence of that case, and it's hard to say which one where, you know, that employer should go for, really. So the second question from this audience member: if the incompetence occurs during the probationary period, does training or transfer of the employee still is training or transfer of the employee still a requirement for lawful unilateral termination? No. So within probationary period, there is a simpler termination ground to use for employers. So there is a termination ground under Article 39 of the Employment Contract Law. It's called termination for failure in meeting the recruitment conditions. So what that means is that when you find out that this employee does not meet the recruitment conditions within probationary period, you can try to go down that path rather than taking the more complicated ground of termination based on incompetence.
Excellent.
Yeah, so for that question.
Brilliant. And we've just had another question in from Renee, who asks, is there a maximum of severance to be paid? So for example, 12 months.
Yeah, so this again depends on the regional practice. So there is no unified answer for this question. You know, in Beijing, some regions are even taking a different approach to others. So yeah, it's difficult to say, really.
Brilliant, thank you, Hongwan. Is non-compete obligation allowed in China?
Well, yes, non-compete is allowed in China with some conditions. And there are some basic concepts about non-compete that you may wish to know. Well, the first one is non-compete obligation is usually set for certain employees, for example, senior management personnel, senior technical staff, and other employees with confidentiality obligations. And the non-compete obligation must be in writing to be valid. And the second one is the non-compete period can be up to 2 years after employment termination. So any period longer than this will be considered invalid and unenforceable. And the last one maybe you need to know is that non-compete obligation should come with compensation. And absent a compensation clause, the obligation may not necessarily be unenforceable, but the employee is entitled to request for compensation or terminate the non-compete agreement if the employer fails to make the compensation for 3 months consecutively. Yeah, there's a lot more in practice, and we can discuss further if needed.
Brilliant, thanks, Chang. And for the time being, we'll move on to our final question before we move on to closing comments. But if there are any other questions that come in, we have 5 minutes left, so we have time. Is severance pay mandatory under PRC laws? And if yes, how should it be calculated?
Yeah, again, this depends on the ground that an employer is using for termination and the regional practice. So there's really no simple answer to this. So you need to let us know the ground you are using for termination and the region you are located in, and we can, let you know the answer.
Excellent, thank you very much. So for the time being, that ends our Q&A session, a very lively session. Thank you very much for all of the questions that came in, some really interesting points that were raised there. Chang, Hongwan, I will hand over to you now just to give us any key takeaways or any closing comments that you'd like to make before we finish. If there's anything that you would want our audience to leave today's session, if there was just one point you would like them to leave today's webinar today, what would it be? I'll hand over to you. Thank you.
Well, thank you for joining this webinar. There's a lot of information under Chinese law that we would like to share with you, but because of limited time, we just chose 2 essential topics today. But to let you know that we just released the comparative guide for Chinese section on Mondac website. So if you need basic information about PRC employment law, maybe you can check it out.
Excellent, brilliant. Well, I think that's a fantastic place to end today. Once again, thank you, Chang, thank you, Hongwan, for your time, for your presentations as well. Incredibly detailed, a lot of important points that were made. We hope that we can have you back again soon to do a second part or another webinar with us. And thank you very much to our audience for the questions that you sent in and for your presence here today. We really appreciate it. So for now, I will wish you a good day and say goodbye. Thank you.
Thank you.
Bye-bye.
Bye.